sections.
Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise Crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you! You started writing your opinions.
And it just makes me wonder, you're dead, bitch. You know, why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is,
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.
Wow, Tim Pool in the house. Tyler Yonke, LPR. Are we rebranding? I don't know. I was trying to come up with some legal pundit report. We are doing a legal analysis tonight. We're going to watch a little stuff. JC's in the chat, says, oh my God, hi, Tyler. Eddie Grimm's also out there, gives us the 07, or I think that's what it is. Hey-yo. Hope everybody is well. Tyler Yonke, LPR, episode 261. Hit the like, hit the subscribe, all that good stuff. I'm going to wait a little bit, let some people come in here. Usually I do a 3-minute open. This is what it looks like for the countdown. Yeah, but we're not gonna do that for tonight. I came in right away. I hope everything's working. Sounds, everything. Bruce, Eddie's in here, like I said. All right, so what I wanted to do today, because this is what we're going to try to do on Wednesdays. We're going to start doing some legal stuff, right? So maybe we can have two sides of this whole coin here, which is people that want to come in and see me rant and rave about stuff. We'll do that on Fridays. But I think Wednesday, I'm trying to do this here. It's busy too, so it's cramming this in. I'm going to try to do some more legal stuff. Okay, maybe we'll get a little different, feelings to all this. Which is today there's a trial going on, and it's Adelson. I don't know if you guys are aware of this. I could break down the situation, but today the defense ended, and they had some people coming on there touting themselves as family law experts. Okay, these are just attorneys. These are just long-standing attorneys in the field, and they testified, and females, and it was barely legal. That doesn't go with the L and the P and the R. The pedo, maybe. Beto? Barely legal with Tyler. That's actually, that's really solid. JC. Yeah, that's really solid. No, I can't. I lost my train of thought with that one. Okay, so here's the deal. I'll break down and so people that are coming in, they're like, maybe you don't know, and so you're like, oh, I want to hear some more about this Adelson case. So I'm going to come in here and see what this loser has to say. Fine. I get a little rambly at times, do this, but I am a family law attorney, and I litigate, I practice. I have 2 trials coming up this next month. So I'm in the thick of it all the time. Okay. Just throwing that out there. All I do is family law. And for the most part, okay. Sometimes we venture off some things, but usually not much. So I'm pretty good. I'm in California, so some things can differ here. But I just want to give you an overview. Okay. Let's back up and do a real quick synopsis of this Adelson case. This guy, Dan Markell, he marries this girl, Wendy Adelson. Okay. Now I'm going to say this and you're going to say, oh, there goes Tyler again. But no, it's not anything it's part of the case. Jews, both come from Jewish families. Okay. Dan Markell is a little bit more strict than Wendy is. Neither one of them are Orthodox. They both turn out to be attorneys. I think he originally was from like Canada, or his family is. But anyway, he's down. They're practicing. He works at the Florida State University, in Tallahassee, Florida, as a law professor. She's doing some legal stuff there as well. They get married. They have kids. Her parents. She has 2 older brothers, I think. And then these parents, and her dad's a dentist, her brother's a dentist, the other brother's an ENT, wealthy family, doing well, fulfilling all the stereotypes. Dan Markel, he's the dad, he is like the law professor, okay? They end up getting a divorce. Now, with this divorce, they go through a little bit of a custody battle. They get the divorce finalized. We're going to hear some more about that today. It's important because then, as the divorce gets finalized, agreed upon, there's still kids that, issues that continue on. He gets murdered outside his house, shot to the head. This is in 2014, I think, 13, 14 in there. They don't know who does it. The kids then go to mom. She moves down to southern Florida where she had been trying to move and the court had stopping her from going. And then, comes to find out 2 people that killed him were hired by a girl that was a boyfriend of these 2 thugs. Now, she also was a girlfriend of the brother of the sister. Now, all those 3 people have been prosecuted, the 2 gunmen and the girlfriend. And then the brother, his name is Charlie, he's been prosecuted and life in prison. Now they're going after the grandmother. It comes out the grandmother and the brother were working together, the grandmother and her son, hiring this guy. Anyway, was the daughter involved? We don't know. Very suspicious. Trash family at best. So grandma is okay. So where does the family law come in? Well, part of this is the motive. So you have this conspiracy, the grandma and her son conspiring to get a hitman to put it out, So there's a lot of this was a contentious family law case. So they brought in the first person that's going to testify that we're going to talk about here is the attorney for the daughter that was in this case. Now, there's too much testimony. It's almost like 4 hours worth of these 2 female attorneys. She comes and testifies. Like, wait, I thought we had attorney-client privilege. Yes, you do. But the daughter waived it because she didn't want to testify about this stuff. And she'd shared a bunch of emails, which also then ruined some of the confidentiality. And then, anyway, this attorney had withdrawn. And then they had an expert to come on to testify about this family law stuff. Are you going to AskCon this Phoenix this January, Tyler? I don't know. Right now I'm saying no because there's a lot of costs involved. I've been doing a bunch of traveling, taking time. I feel like I have work to do and I need to be here, but then I'm like, oh, that's in January. Maybe. I mean, no one's asked me to perform. I'm not just going to go and willy-nilly and hang out with the plebs. I need to perform. I need to have a show or something going on there. Okay, so anyway, what does this have to do with Mark Cuban? I don't know that it does. All right, let's get to some of this testimony, and I'll try to walk you through, and then we're going to actually just listen to it all. This is the attorney for the daughter, okay, for Wendy Adelson. This is her attorney who is now testifying. I'm going to play a snippet, a little bit of hers, but then they brought in, like I said, this expert. And that, to me, I'm going to try to play most of that. And you may be a little bored on it. Perfectly fine. Those that like this, it's fine. Because what I'm going to do is, from an actual family law perspective, give a little bit of a breakdown. Now, these 2 women, these 2 kind of experts, I guess, in a way, they've been practicing for quite some time. Okay. Now, I'm also going to play a clip when we get to it later of Peter Garagos. I think that's his name, the lawyer he makes some comments. This is the problem, and I know I watched Emily D. Baker and a bunch of different ones today. When you're not a family law attorney, some of this you could just maybe spit out as an attorney, because it's a little different world. And what mostly the different world about it is when you're in law, there's always 2 arguments, right? There's always 2 arguments you can make. You see this all the time with even things in criminal law where they're making arguments in court. The problem with family law is it's mostly a court of equity, okay? There's courts of law and there's courts of equity. Equity means fairness. So if you're out there in a court of law, it's all about, here's the rule, bop, 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 elements, bang, bang, bang. Court of equity, it's like, well, is this fair? The judge has a lot of discretion. And you have that with family law a lot because there's issues with custody that you can't just dictate every little thing. You expect the parties to behave as normal adults, perhaps. Okay, let's get to Joe Exotic. Charges $100 to go on one podcast. What if you brought him on to have him give some legal advice? I don't have people. I am legal advice. Okay, let's start this out. I want to make sure I'm at 1.25. And I haven't really picked, I listened to it all today, and I don't have little segments, so we're going to start out here, and if I'm bored, we're going to skip through. And if we need to pump up the volume, we will.
We put on all of that, and then at the end of our testimony, the judge asked to speak to counsel, which happens a lot, and she took counsel out. It was me and Professor Markel's lawyer, and she told us she understood why Ms. Adelson wanted to. Okay, let's give some context here. Sorry. So they were going through this divorce, and the mom wanted to move to the South. So she said, let's do a move away order. Okay. I want to relocate the kids. Now, there's best interest of the child. Different states have different barriers for this. Change of circumstance, best interest of the child. But like California, if you've never had an actual establishment of custody, you just basically, it's the best interest of the child. Otherwise, you do what's called LaMusca. It's these different cases that break down some of the benefits, and it's always kind of based on the child and their experience, or what's best for them. Just relocating isn't quite always going to be the thing. They were having a trial on this, okay? In family law, it's almost everywhere. It's a bench trial, so it's just you and the judge. You don't have a jury. So with that in mind, they were going through, and the dad presented his case, and the judge is basically like, yeah, before you even put on your case, I'm not going to grant, I'm already on his side, and you haven't even presented your case. So this attorney walks out and has a conversation with her client, and there you go. But she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
During that hearing, or after the judge made those comments, did Wendy go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendy about that, and then Wendy's parents were there, and I actually spoke to Wendy and her parents, and then she went and spoke to her parents again, I think, if I can remember.
The whole reason they're doing this is because grandma had someone killed, and so the defense's point here is like, I'm sorry, but this was not such a contentious issue that she didn't actually go and hire these people to kill. Okay, she didn't do it because this wasn't an issue that we really needed to worry about. Law and crime, still a-holes about copyright claims. I haven't had a problem with them. So no, I don't think so. Matter of fact, people are streaming their stuff all day long. Doesn't seem to be a problem. So hit like, subscribe, get this thing pumping through the algorithm. I mean, I'm in there watching this thing the other day. If I had time to just sit here and do nothing, this Emily Baker's doing like 200,000 views on a live stream. It's 9 hours, and I'm billing while she's doing that, and I don't know who's making more. I don't. Okay.
Remember, it was a long time ago, but I think she spoke to her parents outside of my presence as well.
Did Wendy ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
So what happened at that point was we went back into court. The judge denied Professor Markel's motion to dismiss because he had filed a motion to dismiss our pleading. She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point in time, I believe it was approximately the third week of June of 2013?
Yes.
And what was Wendy's reaction?
At that point in time, I think she was upset that she wasn't going to be. I mean, nobody wants to not win their case. She was upset. She was always calm during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak.
I'm going to go to cross-examination because that's where it does start to get a little bit more interesting. This guy, I mean, he brings out a lot of stuff, and there's let me jump in here and see if there's anything interesting at this point.
Personal towards me and said that I had committed fraud and that
Okay. So Markel, so they come to this relocation, a move away basically for the child. It's denied. Then they go to, they actually go to a settlement. They resolve everything for the property. So here's what you have. Divorce, it's a lawsuit, okay? It's legit. It's a straight out lawsuit. It's in civil court. It's like suing your neighbor. Now, to have jurisdiction for this specific court, you have to have been married to this person, okay? So there you go. Now the court has certain ways to have jurisdiction over you for all kinds of things. This is one. So you're married, now you're gonna get divorced. This court has jurisdiction. Boom, you're under this court. So with this, by the time you get a legal determination of your divorced, by the way, you can get what's called a status-only divorce. You can get just the status. You want to get remarried? I've had this where cases go on way too many years. People are finding new partners. They want to get remarried. So I've had two that then we bifurcate the divorce, the status. They're legally divorced, but we haven't finished the whole case yet, right? So everything else is still to be determined, but they can get remarried. I've had people get remarried and divorced before the first one is over, okay? Yeah, anyway. So you can do that, but the point is also you can have this final jurisdiction, determination that you're divorced, but now maybe you need to enforce some things in this divorce, such as I bought out the house and she owes me money. You can still have determination. The court only has jurisdiction to then enforce what's in this settlement agreement, okay? But your kids go on. The court has jurisdiction over them until they're 18 and out of high school, typically in most jurisdictions. So with that in mind, let's keep going here.
I should be disbarred based upon what had happened.
So Mikhail, he filed a motion about that he was supposed to get some more money or something like this, or that they didn't fully disclose some bank accounts, and retirement accounts, I think, investment accounts. And then he said that this attorney made some problems and that she personally should be disbarred. So she's got motivation for testifying here today.
I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness and a lawyer representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Did that result in the hearing that had, now, let me back up. Had you been able, prior to withdrawing, to schedule the hearing on your enforcement motion as well as Mr. Markel's motions? I had it scheduled. It was scheduled, but then I had to withdraw because he filed that pleading after it was scheduled. So I had to withdraw, and I called Jimmy Jenkins and asked him if he could please represent Ms. Adelson. He said yes, but he needed more time to get up to speed on that case.
Okay, so now we're going to move ahead. I want to get to the cross-examination, and let's see if we are anywhere. No, she's still doing direct. Okay, so they go to lunch. There's the judge. He may look interesting, but he's actually a pretty good guy. Then there was some problems. Okay, let's see when she starts to come. Okay. That must be their lunch hour. Did they not cross-examine her? I thought they were going to cross-examine this bitch. Maybe that was redirect here. I do want to get onto some of this. Sorry, I want to get onto some of this. This is where I should have perhaps timestamps. Uh-oh, spinny. Okay, well, I guess not. Okay, so now we're going to bring on the expert. So this is her. There were some issues about whether she should be able to testify because she was in the courtroom listening to the other one. That's not really appropriate. Okay, so here's her on direct, and I think I'm just going to go through to the cross-examination because that's really the most interesting part. She basically testifies that it's not a contentious trial. That's what you really want to get out of this one. Okay, so now they're on a break. Sorry, this would be better. Okay, I think here we go. Let's get to, look at that exasperated face. That's what we have coming up. Okay, folks. Look at this attorney over there. She wears like her dad's suit or something.
Adelson Markel divorce compare across the variety of cases that you've handled.
Simply, it was routine. It was amicable. I've done
similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markell's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think.
I am not sure. Did I go past the... No, I think this is still all direct.
Responses to the article or something. They weren't technically correct. They were verbose. They were hyperbolic. He used a lot of inflammatory language. But when you really looked closely at his requests of the court, there was no there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-examine.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contention.
Okay. This is where, and by the way, yeah, it's fine. I get it. I have all these cases. I should be able to determine what's contentious and what's not. We resolve, things quite often, quickly. And that's her contention in this case. However, I've resolved cases quickly that are contentious, okay? Sometimes they have it depends what the issues are. It depends how each party is. But this is why you hire an attorney oftentimes, because we come in there as a professional that's emotionally removed from the case, should be, and therefore you're able to present all these things. In fact, like she talked about how there were name calling and all kinds, this guy, his pleadings were bad, is all the stuff that wasn't. Those get people riled up. I have people freaking out simply from getting served the papers, and it says on the petition, which means nothing, because once you file a response, now you don't have a default and you have to go to court over everything or work out an agreement. And it says he or she is going to be paying me spousal support or my attorney's fees, and they are just up in arms. And it's like, well, that's just something or they call you names and they want you to defend it. And I'm like, that's not material. It's not even at issue here. It doesn't matter. The court doesn't care, but it doesn't mean that they don't care. But, we're removed from it. So what I may feel is not contentious, my clients may feel that it is contentious. Anyway, let's keep going.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with.
So
but
isn't the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world? Do you agree with that? Do you agree with that?
Ms. Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree. That's one reason I called Kristen, is Ms. Adelson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm, and I find that when I litigate against her, we reach resolution.
But that's the attorney. Right. I get it. There's certain attorneys I like to work with or against because we can get to the solution. And there's often the ones I don't like are the ones that act like it's their child, like this Miss Adelson is the attorney, where, you're just digging in. You're not going to listen to anything. But what we do is we set expectations and we go from there. And attorneys that are willing to do that and actually get a resolution and move on, you can work with them. You can actually say, we've got a couple here. These two, they're a little crazy. However, I've got control, and here's what we're doing. that has, yeah. So I'm putting basically, this lady is, look, this is the bad part. And she deserves to have the criticism come on her. She got hired to come in here to talk as an expert. It's her best friend, or sounds like it, a good, I think it was even law school classmate that was the attorney we just saw testifying. Now this one's hired as another family law attorney to give her expertise on all this. Why? Why is this even an expert? You don't need to, this is one, it's horrible, I think, for the defense, but it's also stupid. And so then we get a rip on her because she's not, I'm sorry, this is where attorneys do get to, you get a rip on them. She's not being truthful. Okay, it's just, and then this prosecutor, I'm not a fan of prosecutors, but this one's saying the exact right. Who are you to say if they thought this was contentious or not?
That people stay measured and calm and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had, something similar to what Mr. Markell would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but...
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say in a way more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not.
Okay. Just look, I practice in front of a judge only. I don't do jury trials, but I can't imagine that look at this exasperation here.
How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you?
Here's the problem, and it's what I talked about early on. We talked about something earlier. Where was it? We were talking about preclusion, basically issue preclusion or claim preclusion. Okay, res judicata or estoppel. Okay, and so you have a matter that's been decided. I think it was when we first did this one here. You have a matter that's been decided with prejudice, which means you can't refile on that. Now, if it's a claim, which is the lawsuit itself, you can't refile the claim on those same issues. Family law has a lot of issues within the claim. The claim is the divorce. The issue could be custody. It could be spousal support. It could be the house. Okay. We're going into court and we're making determinations on this. A lot of these times, those are temporary orders that can be modified along the way. Some of them can't. It depends what it is. Child custody. It's a temporary order. It doesn't, and you have it, you typically don't have a permanent order. That one, you have to have a substantial change of circumstances, which is very hard to overcome. For the most part, it's modifiable all the time. Child support. Spousal support, maybe not. Domestic violence restraining orders, those are typically done with prejudice if there's a determination one way or another. You don't just get to keep coming back and filing over the same issue and issue. So this lady's saying, look, they got this whole case. She did a move away. It didn't go her way. They stipulated, and then they resolved the whole case. It was done and over. These kids were like 3 and 4 years old. The custody was not going away. Matter of fact, he had filed additional items with that. That needs to be understood with the family law portion here. And I think this prosecutor, she seems, maybe she did family law. She seems to understand the shit that's going on to ask the right questions.
Would you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
And I talk about this all the time about credibility of a witness. When there's something that is obvious and you have to answer where in this case, the prosecution and on cross is trying to get you to admit to something, you admit to it. If you can't admit to it, then they're like, oh, they're just slimy. And that's the way she's coming across to. That's an easy answer.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
Okay, come on. I mean, how do you not get that reference? Is this lady so snooty that she doesn't get that reference? Who didn't get that reference in here, people? Texas Spy Historian said, gave a like. Have a great stream. Thank you. I appreciate it over there on Rumble.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that. You can't agree with it. Strike the question. You were asked, let me ask you this. Let's go on to something else.
Strike the question.
Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law?
I have. Had a client. She was good. She was a mom. She had, I think they had 4 kids. She went down a nasty route. She had a nurse, had access to drugs at work, started to take them, got hooked, going through a divorce. The dad is like, I was representing her. Her dad came to me and was like, you got to help. I did as best I could, but she was having trouble. We did a full agreement, settlement conference, full agreement. And she had this boyfriend that was kind of trashy. He kills her. He beats her up and she dies before we enter it as a judgment. So we did what's called an abatement, and dad gets everything as he should. And he already had the kids. It was super sad. I've had another one where client was in federal prison for doing gun parts that the got caught up on with the feds. We're going through this. It was getting somewhat contentious. There was some money involved. The next thing you know, she dies. Well, that was cancer. That's a little bit different. He gets everything. I had one other one die in the middle of it too. That was a car accident, but it happens. No suicides.
I've never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was litigated. It was literally the day after the petition was filed. And he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow.
I don't know that it's shameful. It's I don't have a problem, and I've been divorced. I don't have a problem with not trying to normalize it. Okay, I don't have a problem with people thinking that it's you shouldn't go through it. Yeah, I'm totally with you. The best is to make, and that's my fear now as a father, is never promise crazy a baby. Try to get your kids to select the correct spouse to begin with. That's very important, right?
Grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey. To that person, it was a reason to commit suicide, right?
Apparently so.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal, it wouldn't be granted, it was buried in there. But the allegation is, grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma.
Exactly.
Exactly.
It shouldn't have been.
So I'll say this. This is my problem with some of this case. If you guys watch Karen Reed or you watch any of these others, Karen Reed especially, they're objecting over and over. I would have objected to that, especially with a jury. I don't even let the judge when it's a bench trial. Exactly. I would say objection as to form. She's commenting. That's not a question. I mean, the defense is just asleep at the wheel on a lot of stuff. They're not inefficient assistants of counsel, but at some point you just like, if you put objections and they're overruled and it's on the record, you at least have a better basis for appealing, right?
There was no proof.
It shouldn't have been, in your opinion.
In my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Or murder.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering.
Just throwing this out there too, that was never testified to. Okay, so she's just putting facts, not in evidence, and they're just letting us go. The defense blows me away.
But I've seen far, far worse.
You've seen worse.
I have.
So have I. But every time someone in a case comes across these kind of things, it's the shit to them, right? It's a big deal. I'm used to it. It doesn't mean that if I'm inoculated to violence, that someone that has violence perpetrated to them, I'm like, well, I'm used to it. That's not the standard here.
Mr. Markell wasn't paying by the deadline. Isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Ms. Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right?
Wow.
Right?
Sure.
Okay.
Yeah, I think on that issue, he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay, well,
No, because he did have the money, but that's what an order to compel is, or a contempt. File it. It has civil and criminal aspects attached to it. They actually arraign you. They give you a chance to have a public defender. This is if you haven't paid your child support, spouse. I just got asked to do one here where it's for like late to pick up their kid. There's a court order and you're not following it. So we're going to file contempt. Each little issue, it could be like each month you miss spousal support or child support is a count. And so many of them, you actually do go have a jury trial.
you sat in the courtroom during Ms.
Can go to
Adamson's
jail.
testimony, didn't you? And Ms. Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Ultimately.
Wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
That is incorrect. So, any of those legal civil ones out here going, hey, you know, this lady was, that is incorrect. I know it's Florida, but they were going through, he wasn't fine with what was in this settlement agreement. So he had done a motion to have it enforced. And they were like, that's not the proper motion. Okay, well, you know what the proper motion is that you could have done back, which was mentioned by the attorney? Contempt. Contempt is, there's a solution, which it can be money and it can be jail. That's why they arraign you on a contempt charge. So I don't think it would have gone there because they would have had to go through this judgment. No, you have an order to pay. You can go through this other way of getting an enforcement, statutory interest and all this other stuff. He's a Jew. Is that necessary? I don't know.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms. Adamson was incorrect on that point, I guess.
Objection, Your Honor. That's a question that we would strike.
I'll rephrase it.
Was the objection again?
It's an improper comment on that witness's testimony.
Please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendy. Jail is not a possibility on that. You don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support. And if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So
I'm sorry, wrong, which is you almost got there. Why is jail possibly an option for not paying child support or not paying spousal support? It's only because someone brought a contempt charge, okay? So you could have done that, and the other lady mentioned that. She knew. I thought this was an expert. That's all I'm getting at.
I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever, and then all of a sudden he comes up with money out of his pocket and he pays, he never goes to jail. So you always have the key to...
Let's stop here. First of all, this is not a Coke Zero. This is a Firestone Extra XPA. It's not a Coke Zero, if that's what you're talking about. Late to the chat, what are we drinking tonight? I have a Voodoo Ranger. Solid stuff. I told you I just had a Firestone XPA. I'm still working on it. Voodoo Rangers, very good. Scott, pay some support. Okay, let's keep going here, folks.
To jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't.
This is taxes. You can go to jail. Why do you pay your taxes? Because you might go to jail. There it is. And I'm sorry, yes, usually if civil issues, they don't have debtor's prison, but if there's a court order, especially in family, you can, I'm gonna keep harping on this because that's what contempt is all about.
And that's just support. There's no jail consequence to the $70,000 to Wendy. It was only the $10,000 to Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see in your review of the evidence in this case Ms. Adamson responding to those questions and Wendy then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were... I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Ms. Donna Adelson about the relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October, maybe?
Okay.
Several months.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right, and if he was murdered, it could happen, right?
Well, obviously.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his...
Okay. Part of this, you go back to this, Dan Markel is a law professor, and their claim is that he drafted all these and then his attorney just like took it and put it in there as a filing because it wasn't great. Could be. By the way, they're doing family law, which is a lot of times it's simply declarations. We do this all the time. It's got to be in your client's words. And I'm like, I need to know what took place. I just filed one today, had to drop it off at the court for an emergency hearing response for tomorrow. And I met with my client, and first of all, he's giving me info, and I'm drafting it's in my words, but it's his words. And then and sometimes people they'll send me what they want or what their take is, and I'm cutting and pasting, I'm fluffing it up because it's got to be in the right way, the right order, but I need their words. So it depends on how good they write, and I'm always making changes either way. And then I'm sending it back and forth to make sure it's exactly what because I've just had 2 trials recently where they've sent me stuff and I put in there, but we're trying to make it. So the last that it goes out is to their liking. And I'm like, you have to be 100% on board on this. I try to make it sound better. I try to have the better argument. I don't need to have all this bullshit that you want to put in here. But then opposing counsel, and I do this too, is bringing up their declaration that they had drafted, that they had signed off in, and for court. Now they're in trial. They're saying something. It's like, well, this is a little bit different. Or what did you mean? You made this claim here. So you've got to all be on board with this. Okay. So this lady acting like I drafted all. What? Are you then put in this person's words? Because I know you're doing declarations.
Motions post July 31st were not based in the law. And I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud, and it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't.
But you don't always know that. We have trials, hearings. It sounds like bullshit, and you have to tell your client what you think the outcome is going to be. But this person is filed, and some, if it's really frivolous, the courts will sanction them, but not enough.
Aren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended.
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adelson filed in October, and the motion that Mr. Markell filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markell amped it up again, and on May 5th he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
Once again, you can have a resolution on some things, like this enforcement, you can only go so far. At some point, it's going to be done and over. The kids' situation, the relocation was saying, no, they're going to stay here, but custody was still a problem. And he filed issues to have custody determined and still heard. And bitch, it's going to last. And you know this, it's going to last until the kids are 18 and out of high school with these families. So don't tell me and by the way, you can have everything else because they resolved everything else, but they're still bitching and complaining about the kids because kids, I tell this all the time, you're going to maybe go to trial. And I'm always telling my client, this is cost-benefit analysis. Is it worth the time to push this, to go to trial? I don't do that when it comes to kids, especially if it's a situation where you're like, hey, maybe one of them's abusing the children. You're not going to put, but it's going to cost me $5,000. You're going to go I'm going to do what I can to have this resolved and to save my kids. So if you really feel that way, that's what you're going to do.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markell's murder, litigation was still ongoing in this case. Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Overruled, the witnesses provided an opinion, state cross-examined.
I guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing.
She's not answering that question.
Nonsense pleadings and motions.
The question was essentially what I just said, which is you can continue to fight until the kids are 18. Matter of fact, the kids are only 13 or 14 now. They'd still have a good 4 or 5 years left.
Better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will.
She encourages her clients to go to these hearings so that she makes more money. And then I get it, but maybe it stops them from doing stuff. Sorry, you never win enough attorney's fees in penalties or sanctions to make it worthwhile. Don't go to court. You're going to save yourself time.
You will by the court and made to pay your fees, then they tend to back off. So
That hadn't happened yet.
It had not happened yet.
And we'll never know when that was going to happen because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
May I have a moment to confer, Judge?
What?
Briefly, you sat through
redirect
Kristen Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
Will this witness be recalled at any point?
Potentially, Your Honor, but she's free to go about her business.
You remain under your subpoena. Please not discuss your testimony with any other witness in this matter. Have a good day.
Okay, I am going to go to this because this is one part. I don't know where I missed it here, but it's right of first refusal. So this is the lawyer Peter Gregos, I don't know, lawyer you know. So there was an issue that Dan Markell was filing a motion because part of this, and I'm going to go back to the trial here because there's some interesting little things here. Because he was objecting to some of the custody stuff. He didn't want grandma involved because he wanted on his it's called right of first refusal. Okay. I'm not always a fan of it. I have clients that want this, and I have a few cases that have just argued with it. They used to have it much more often multiple years ago, I don't know, 8 years ago, and it's kind of waned its way back from there, not as much. But the concept is this. The parents are the most important part of this child's life, okay? So, and you don't have necessarily enough custody. So if one parent is going to be gone, and you usually have and the court usually delineates, otherwise it's out of control, a certain amount of time. If you know, let's just pick a time. If you're going to be away from the kids for more than 2 hours, then the other parent has the first right to watch the kids. Okay. Now this isn't, you know, you're on your normal time. You schedule, you know, play dates and whatnot. That's not what it is. It's typically this. It's typically about maybe picking kids up and back and forth after school. It's daycare, anytime you're not with them. And it depends what the situation is, right? So these are all really, really fact specific for the arguments, okay? Now, Peter talks about here, someone brings this up and he gives a little answer, which actually I think I'm gonna have to put this down to reset to 100. Let's go here.
Plain Jane said, that's not true with first right of refusal. You're supposed to offer the other parent the time before a third party. I disagree that it's every single time.
Sometimes, and it goes on, sometimes the parties agree on a minimum amount of time, yeah.
Like she said, you're allowed to do sleepovers with grandma. You're allowed to set up things where grandma can watch them. And if you happen to be out while they're hanging out with grandma or going to a friend's house, you don't have to offer to them, go to the other parent's house every single time. That's kind of how she explained it. That's my understanding. I'm not a family law lawyer. We don't need to debate it, but I understand if people want to disagree with kind of her explanation of it.
Yeah, we're going to debate it, right? So the reason we're going to debate it is because it has to be specific. And I don't know, we didn't see the pleadings there. So don't just go off half-cocked. I love Peter, but don't just go off half-cocked saying, you know, that's not what it is. You have to have, the point, I have a case, and it's all, like I said, fact-specific. What you have to be able to do, I just had a case where the judge said, well, okay, fine, we'll implement right of first refusal. My client really wanted it. She wanted it anytime he wasn't going to get it. Because why? Because he couldn't. She's like, he can't actually have the kids the times that he says he wants them. He just doesn't want me to have them. So I want right of first refusal because he's actually going to be at work. So we're like, fine. So we push for this. And then he's like, my mom can watch the kids. And she's like, but it should be me. So the judge had to carve out that if he is gone for a certain amount of time and his mom, then she gets the right of first refusal. So his mom, because you know what adult isn't living with their parents still, his mom had a specific carve out. Otherwise, it's exactly what it says it's going to be. It's because if a parent's going to work, if they're going, now you don't want to have it to such a narrow time frame that you're like, you know, you're 10-year-old, you're going to leave at home, you're just going to go stop off and get something at the grocery store. You got to call dad or you're going to be caught. But that is the idea there. So the point I'm getting at here with Peter is he may be right, he may not be right. We don't know. This is very, very specific, and you can carve all this little bit. This is why, one, you can have contempt for all these things. You go to court for all these things. This is why family law can be difficult at times, because we don't know how specific that order is. I get recommendations from family court services where the parties go to mediation, and then there's a recommendation. And I look through there and I'm like, tell the client, talk to me about any ambiguities here. That's what I want to go into court, make sure there's something that's just not innocuous, that it's like, you get them the third Friday, dad maybe gets first, third, and fifth, weekends of the month. You're like, well, fifth? You're like, yeah, there's like 3 or 4 months out of the year that have 5 weekends. But when does the weekend begin? Is it Saturday? Is it Friday? Right? So you got to specify these kind of things to know, and you got to be lawyerly about it. So these kind of things. So right of first refusal, we don't know. Anyway, this is kind of where we're at. JC gives the mouth thing there. Okay, let's go back here, because then what happens is the defense basically closes their case down. Okay. They're pretty much done, and they're deciding whether this crazy lady is going to testify. I wanted her to testify, and whether she's going to testify in her own case or not. And is that, typically a good thing? So the judge, let's see here.
You need to place the defendant under oath concerning this. Ms. Adelson, please rise, raise your right hand. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. Do you understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you, concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further call to it?
Yes, Your Honor. The waiver is specific as to the counsel that are...
Okay, I'm sorry. This was not the one I wanted. This another attorney comes on there. Sorry. Then one more witness, and then he asks. Let's go here.
Point 1, introduction to final instructions.
Where is? Not there. Sorry, I thought we had this. I should have got timestamps. See if this is it.
We are not finished with the colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains. As it relates...
So they asked, are you going to testify? The guy's like, I need more time to talk about this. The judge is like, no, you've had a lot of time. I want you to, are you going to testify or not? And they're like, they had a little, 5-minute break. And then he brings it back.
Your right to remain silent and your right to testify. What is your decision concerning these two rights?
First of all, I want to handle this question. C Stars, thanks for joining us. Donna's female attorney, there's 2 of them, but one only, I imagine you're talking about the one that looks like she's dressed in the 70s with her hairstyle, but then also like in the other attorney, the male attorney's suit, because it doesn't fit her. Drunk, she seemed drunk today. Anyone else notice that? She was just sitting there making faces for a very long time and then awfully quiet today. Yeah, so she wasn't the person doing this. The direct examination and the redirect, or doing it was all the other guy. I don't know. Maybe that's why he took over. She bothers me. Her little, I don't understand Skype and these other things. A little bit spooky.
This time I don't want to testify.
Very well. As I previously stated, the jurors will be instructed that your
at this time, I don't want to testify.
Silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Did say that, Judge. May I have a moment to confer with co-counsel?
Go ahead.
So she's not going to testify. We're going to miss out on her testimony. Bummer for that, because that would have been interesting. So this case is going to conclude. I just thought it would be fun to kind of go through some of this family law stuff since I deal with it daily. And by the way, it wasn't necessary for the defense, if you followed this closely, it wasn't necessary for the defense to even bring up these experts. I don't think it does much. This lady is going to burn in hell. She's definitely, in my opinion, guilty. I mean, they have so much on her. It's just a really sad situation. You know, some of these cases, I like to come in here, take a look at them and try to be a little bit more, I don't know, neutral and just take it from an attorney's point of view. But this one they're just disturbing people. The stuff they wanted to do, it was just, they killed the guy. So that was a bit rough. So there you go. That's what we had on the day. Let me see. Do we have anything? Let me look and see if there's anything legal coming on that I just want to take a look at real quick. We got some court docket stuff for the Supreme Court. Government's canceling Harvard contracts violated First Amendment, judge rules. Okay. Should have seen that one coming. Claims over A&E's Miss Cleo. Her rise and fall dismissed. Okay. I don't know if you know who Miss Cleo is. She was psychic. Would Graham Linehan's, if all else fails, punch him in the balls, be protected under U.S. law? That's the guy that went into, was it the UK and was... okay, well, there we go. I think that's what we're going to do tonight. It's been an hour, so I'll try to do one on Friday. Taking the day tomorrow, got to take a day off. Then I should be back on Friday. See what we have going on then. Yes, no Tower Gang, but we do have the Tyler Yonke LPR show. So thanks for coming in here, people. Hit the like, hit the subscribe. And as always, let's see which music we want to go out on. Let's see what this one going on. As always, follow the show. Make sure you spread it out there so we have whatever. If you have any legal questions, let me know. Take care.
That is a career-ending slur. It is a career.
Never mind.